Lawyer. Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. It is Tuesday, which means it is our Tuesday night live program. So I want to thank everybody for joining us. And obviously, the breaking story of the day is what we talked about in the video that we put up earlier today. And that is the Kare Read case. Now, I remember when the lovely Miss Kristen and I were at CrimeCon in Nashville last year. The case was still ongoing. And I remember having conversations with people. They were either all in on Kare Read, like guilty, or all in not guilty. People had made up their minds. Well, a couple of things are changing my mind. And I have said it that I would have probably voted, if I was a juror, to find her not guilty in the first trial. The prosecution just had some problems with the case. It didn't flow very good. The defense had the element of surprise. And then they had the whole mistrial thing, right? The defense kept saying, mistrial, mistrial. The jury kept saying, we can't agree, we can't agree. Judge says, fine, we'll go back and deliberate, try again. Judge, we're at an impasse. The judge is sent notes from the jury. We can't decide. We're deadlocked. And then they come to find out after the judge declares a mistrial, which is what basically the defense wanted. The jury says, but we reached a verdict on 2 counts and we would have found her not guilty. So the defense says, wait a second. We want to have jeopardy attached to those particular counts. And the judge says no. And the Massachusetts Supreme Court says no. All right. And then we come across, and I have said this before, and some people, oh, you don't know what you're talking about, Scott. You've never tried a case multiple times, have you? Oh, yes, I have. Several times. And the defense never does better the second time around because the prosecution knows exactly what to expect. And what have we seen in the pretrial motions hearings from the prosecution in the Kare Read case? They're trying to keep out all of the witnesses that testified. They're experts, challenging them, getting another shot at them pre-trial as to why they shouldn't be able to testify. Good stuff, right? It's good attorney stuff, good lawyering going on there. And then today, we had video in our previous video today where the prosecutor, Mr. Brennan, got up there. And after some of his inquiries with the federal United States attorneys and the consultation that the feds did with some accident reconstruction people, Kare, I think is their name, ACCRA, and some of the people that testified at trial, I think one of them was Daniel Wolf, and there was another guy, I believe, as well. Well, it turns out that they're not so impartial like they wanted the world to believe. It turns out the defense paid them a bill. What was it? $23,000 for their testimony. But yet at trial, now emails have been turned over, and the bill that the defense paid to these Kare experts, guess what? It was all a sham. It wasn't disclosed. It was in violation of Rule 16. Discovery. When you endorse an expert and they're a paid expert, you have to endorse them as such. And when you make it out to be like, we've never met before, we've never communicated, have we? Oh, no, we have not communicated at all. And then it turns out they have gone over the direct and cross-examination, anticipated cross-examination questions beforehand. And guess what? That should have been turned over, right? You can talk about questions you're going to ask, but if you have done something specifically to prepare, i.e., email questions like question, answer, then you got to turn that over. If you paid them a fee, you got to turn that over. You got to disclose that. But when they go in there and perpetrate, do I dare say perpetrate a fraud? Because Judge Cannon, who I have not been a huge fan of during the trial here, she did not look happy. And she said, we're going to suspend today's proceedings so everybody can be prepared. And, this could be, I think her words were extreme, egregious, could significantly impact the defense. Like maybe she could say, oh, Mr. Jackson, defense counsel for Miss Read, guess what? We are not going to let you be able to participate in the great state of Massachusetts because we don't think that your character is up to snuff based upon what we've recently learned. And Mr. Brennan, the special prosecutor, and I have told you wrong. I've told you before. I've told you this before. This new special prosecutor, he's good. Former prosecutor, I think he was also a U.S. attorney. Then he went into private defense work, doing both state and federal work. They bring him in, hire him in as a hired gun. That's what he is. Kind of a smaller jurisdiction, need a little more experience. They bring in a former top prosecutor who also has experience. And what does he do, right? He knows where to dig. He knows what if I was the defense attorney, where would I go dig? Where would I go see what the defense is doing to try and turn the defense case upside down? He's found it. He found an email exchange between these ACARA experts who it was presented that they were hired by the feds for their investigation. And we just have no idea. I have no idea what you're going to say, but we're just here for a quest for the truth. And as the special prosecutor noted that, this is not a case where it was absolutely, we forgot to turn it over accidentally. This was intentional. And it wasn't like, we were trying to play within the spirit of the law, of the rules. I think one would argue it's downright cheating. And the Judge Cannon, she didn't look amused. She did not look amused. So a couple of mistakes the defense has made here. All right. And hey, I get it. It's a difficult case. I'm sure a very difficult client didn't really know, I saw her in court, Kare Read. She didn't really talk much. She did good. But I don't know if you all have seen it. We've got it queued up here. She gave an interview the other week. She gave an interview to a local news channel there in Boston for the Super Bowl. She did not do herself any favors, ladies and gentlemen. And I think it may be further icing on the cake of this alleged misconduct. And I mean, it's going to be, listen, I don't want anybody to get in trouble. We don't. Okay. But I have said this before, and I will say it again. And this is what I tell all of my young attorneys. I tell everybody in my office, I never met a client worth going to jail for. And I've never met a client that has paid me enough money to jeopardize my law license. Just not worth it. That one client, it's going to be a flash in the pan. They're going to love you or hate you by the end of it. It doesn't really matter. But if they hate you because you lose, guess what? That client is going to throw you under the bus. It's just the nature of the business when you do criminal defense work. It's the nature of the business when you do this. So although, Miss Kare Read probably thinks Mr. Jackson is the greatest thing since sliced bread, Guess what? If her defense case gets gutted and she goes to prison, who do you think she is going to throw under the bus first? Her attorneys. I had no idea what was going on. Oh my God, I did this. How am I going to afford all this? It's going to get ugly, ladies and gentlemen. So what I want to do is, and I don't think Kare Read, okay, somebody needs to sit down with her. I would have thought that somebody in her defense team, you can actually hire people to work with your clients. If you can't do it yourself, there's actually people that you can hire to work on practicing testifying. Because some people are just terrible at it. And I don't know Kare Read at all. Okay. Frankly, whether she's completely innocent, wrongfully accused, or whether she is guilty as sin, don't really know. We're going to let the jury decide. But as I said, the second time around, it never goes well for the defense. You got that one shot, ladies and gentlemen. And now the prosecutor, this is his only job right now, is to take down Kare Read and possibly take down Kare Read's defense team. Because if they knew this and they made these misrepresentations in front of the judge, and these witnesses testified to things that were not true, they may have to do what people are doing in Washington, D.C. and start Googling criminal defense attorney, perjury. It's gonna get interesting. So the Judge Cannon, put a stop to the motions hearing today and said, let's come back next week. She wanted to do it next Tuesday, but Mr. Jackson wasn't available until Wednesday. Now, Mr. Jackson, when he left the courthouse, I'm not really sure, because apparently it's unclear whether the United States attorney turned over these documents or the defense actually turned them over, but a little late. And maybe they did it because they knew that they were going to be discovered by the defense or by the United States attorney to the prosecution. Now, the other thing is Kare Read, now she's doubling down. She wants to go to federal court on a habeas, saying that it's a double jeopardy because the Massachusetts Supreme Court got it wrong on the whole issue of, if they don't take the verdict, there's no verdict. It's not that complicated. I get these guys are, doing what they have to do, but you can tell it's one of those cases where it's a criminal defense fund, so to speak, because they're leaving no stone unturned. Whereas if the client was paying for it, you'd have to make some, tactical decisions of, is this really worth spending your money on? Okay. So I said the Kare Read has made a couple of fatal mistakes. Okay. And we're going to show you. Okay. The first one was the attorney screwed up on the mistrial, made a huge blunder. If there were in fact misrepresentations made in the first trial that the attorneys knew to be material misrepresentations. Oh, our Kare representatives. Oh my goodness. We had no idea. They're just here, a quest for the truth, and they're telling it the way it is. And third is this huge interview that she did. All right. So I want to play it. I'm going to be here and I'm going to comment. I'm going to tell Frank to stop it at certain points, because I think it's going to be, I don't know. And you can correct me if I'm wrong. Some people like me. Some people hate me. People don't like some things I do. You get it. I don't, it doesn't bother me anymore. When I first started doing this channel, you're an idiot. I would get all fired up. Now it's like, hey, you either love me or you hate me. Maybe it's somewhere in between, but I don't care. Okay. You can go choose. That's the beautiful thing about it. But Kare Read is in a situation where she has to make people like her. And she is clearly trying to influence the jury panel potential veneer, the jury veneer, potential panel of potential jurors in this interview. And I'm telling you, it's interesting. So let's go ahead and start it. I'll tell Frank when to stop it, and I'll jump in here. This is the interview that she gave to Boston 25 when during the Super Bowl. And I'm telling you, she did no favors for herself. We will cut back in and we'll stop. So go beyond.
I have nothing to hide. My life is in the balance, and it shouldn't be. And I believe sunlight is the best disinfectant, and that's been our team motto since inception. I think the more I've seen, the more information the public has, the more they understand what we already know.
And when we talk about the public, there's so much going on in the atmosphere of this case. How much of that do you pay attention to?
I pay attention a little bit to everything. The parts of the public that seem a little dirtier than others, I have close friends and people I trust that filter through it, because there are threads of important information in every channel of the public, on social media, just out and about in Norfolk County or in Suffolk, through our emails. So what I can't manage or don't want to manage, we have a lot of it covered from people that we trust and people who support us.
People said some pretty nasty things about you online. Do you read that? Do you process that?
I read some of it. I don't take it to heart, but it's bothersome. But I understand why it is. There are bad, evil, nefarious players in this. There are people who are adverse to other people in this whole case, people who support me. And I've known my whole life, as does everyone, that there's not a lot of good in some people. And it doesn't drag me down in any way. It makes me feel like we're covering ground here. The nastier it gets, the more I know that we're making an impact to people that have a lot to worry about.
3 years have now passed since John's death. How much do you think about him with everything else that is going on?
I think about him in terms of his final days, his final weeks. I mean, we have his cell phone, which a cell phone to anyone is like a diary, and it tracks everything you've done. And I've gone over and over his final movements, his heart rate, his injuries, the time that he did everything that day and the days leading up to it. But I've said this to other people. The time that I spent with John, 2 years, it's now been 3 since he's gone, since he was killed. And I'm a year beyond. I've eclipsed the time that I spent with him. And I have very mixed feelings, when I look back on John, because I see a lot of poor decisions that were all precursors to his death and to this nightmare that I'm living. It's
poor decisions by whom?
By both of us. Just drinking, being around the wrong people is chief among them. Wrong people for the weeks leading up. They wouldn't have been people I would have chosen on my own to be around.
Have you been able to start a new social life, a new dating life since this?
No, I have my friends that were always in my life. I'm closer to them than ever. And it's been kind of a bittersweet silver lining is I don't know that I ever would have known my friends and family had this in them to be there for me in this way. So I feel very fortunate. And I've met so many new people. And that's enough of a life for me right now is, we go out for dinner just to get out, and we end up just kind of hungered down over a table discussing the case. And I value their input, and I'm content with my social life, even though it's really just socializing about the case.
How big is Kare Read's inner circle?
My inner circle, well, half of it's my attorneys, who we just talk so much. There's always so much ground to cover, and we can't wait until trial starts to really begin strategizing or going through the details. We do a little bit every day.
Do a lot every day.
We do I should say we do a little bit in proportion to the total task at hand, but we cover a lot of hours every day. I probably talk to Alan and Liza each 3 or 4 times a day. And I think it makes us all feel good that we're going to be that much more prepared when we have to do this for round 2. But my inner circle, I don't know. It's bigger than it was. It's bigger than it was before, but it feels stronger than it ever was. I know that I can trust the people that I chose to have in my life.
Is that 5, 10?
10 maybe.
Okay.
Really, really tight, it's probably 5.
Alan, have you ever had a client who's advocated for themselves as much as Karen does?
Not as articulately or as intelligent.
Continue this. I don't know about you, but if I was going to have a client go on local TV before my client has actually gone to trial for the second time, knowing that anything she says can and will be used against her. First of all, she's saying everybody's involved as an evil person. She's the victim here, but maybe some poor decisions were made, hanging out with some people, doing some drinking. I just don't think, this is just me. This is just me. I mean, we haven't heard a whole lot from Kare Read until now. But just her mannerisms, she's not coming across as a very likable person to me. I don't know. Let's continue. It's going to get good here in just a second because, well, Mr. Jackson starts talking, and I think he's going to regret some of what he has to say. That's why you usually don't go to the press during your trial. You'll wait until afterwards, and hopefully you win. Let's go ahead and hit it again. Thanks.
Gently, as Karen does. Karen is an innocent woman falsely accused. She could sit back and say, go handle this. You're the professionals, go deal with it. That is not in her personality. And we're a better team for it. She has an encyclopedic knowledge of literally every single page of the discovery. I've never seen anything like it. She has an analyst's brain. She's got a rapier intelligence that is attendant to this type of analysis. Very, very smart, very motivated. She has no off button. I'm getting texts. I wake up, I'm on the West Coast. So I wake up, she's been awake for 3 hours. And nearly every day, I feel like, damn it, I've fallen back again. I've fallen behind again. Liza and I have to sort of get back on the treadmill and catch up with where Karen is today, because she'll literally just pick something out of the blue. To me, it's out of the blue. To her brain, it makes sense for her to pull this document or pull this report and say, well, have we thought about this paragraph or this sentence or this word in this report here or there? And then we gather together as a team, me and David and Liza and Karen will get on the phone and talk it through. So she's been, more than any other client I've ever seen, any other client I've ever met, she's been at the center of her own defense. She knows she didn't do this. She's motivated to make sure that the truth comes out.
Has she made any seminal decisions in this case? Have we seen any filings that are directly from her decision and her thought process of how things should play out?
The better question is, have we seen any filings that she didn't have a seminal investment in, a decision about, a suggestion about? Every single thing that you've ever seen filed in this case has gone through Karen, at least I mean, some of them are hyper legal, right? But she's educated herself on, she'd make a better lawyer than most lawyers these days. But she will have an impact, and she's got a seat at the table in terms of strategy and tactics that we use every single day.
There are so many people who have never met you, but are so invested.
All right. So just real quick. Now, there's the lawyer covering himself if things go bad. She's been involved in everything that's been filed. She's reviewed it. She's educated herself. She's familiar with everything that we're doing as far as tactics and the legal procedures. Why? In case it comes back, she's going to, I didn't know what was going on. It's very interesting. And hey, I get it. She's invested. It's her only case going on. But if you have a client calling you 3 to 4 times a day, oh God, that's brutal. Like, let me get some work done. Like, you're not the lawyer. Sit down, shut up, and let me do some of the work for a while. All right, go ahead and continue, Frank.
Invested in your life and the outcome of this case. I know there are some who adamantly support you, but do you ever worry about your safety with the people who do not want to see you succeed in this case?
I did more earlier on. I feel more insulated now. I feel safer that people know, because if anything ever happened to me or someone that I love, I think a lot of people would know where to look. So that makes me feel safer.
Have you received any credible threats?
Yep, I have. There's been some online that just the fact that someone's brazen enough to even post something like that gives you some insight into their stability or lack thereof.
People showing up at your house, calling your private cell phone?
No, that has not. I've really not had my physical boundaries impinged in any way, nor have my parents. I think by and large, very large, there are very friendly people all around me.
Your defense strategy is the most aggressive I've ever seen in a case. You've taken on the DA, you've taken on the judge. How much of that is Kare Read? How much is that the team?
Probably equal parts. The defense strategy comes down to probably 3 or 4 words: get the truth out. That's the defense strategy. It may be more aggressive than you're used to. The conduct in this case is more dire than I'm used to. I've seen a lot of cases. I've been doing this for 30 years. I don't think I've ever seen a case with as many questions, as many suspect actions, and as much suspect conduct as I've seen in this case. There is unequivocally corruption in this case. There are absolutely cover-ups in this case. There's conduct by law enforcement and the DA's office that the likes of which I've never seen. And my job, our job as a team, is to get that truth out. I'm not going to sit idly by. Our team is never going to sit idly by and let an innocent woman be convicted based on false evidence, false pretenses, cover-ups, agreements and decisions on the other side to hamstring the defense, hamstring our ability to get the truth out. I'm not going to sit idly by to do that. So is it aggressive? Sure, it's aggressive. But a woman's life is in the balance. So yeah, we're going to stay aggressive. We've been aggressive. We're going to stay aggressive until the truth comes out.
I think it was 4 words at the end of the last trial, and it was, "I'm going to declare a mistrial." What was that like for you to take in?
It was the outcome that I had thought about the least. I had thought about the best case scenario, and I always think about the worst because that's how I'm able to process. I have to think it through. How will I deal with this? Who will fight for me if I'm not sitting here to fight for myself? And of course, I thought about an acquittal because I know I deserve it. I had not really thought about a mistrial. It was only a couple days. It was like day 2, the end of day 2 into the deliberations, that both David and Alan told me separately when we were in the church next door that this could be a mistrial. And the prospect of that at that time during jury deliberations was a gut punch. But then when it was declared, it was such a relief that I was free. I was free to sleep in my own bed, hug my parents, continue to work on this case. My immediate next worry was, I hope I have my team available to go to battle all over again. But those moments, waiting to hear 12 strangers determine what is going to physically happen to you for the foreseeable future or forever, when you're able to walk out a free woman or man, it was an incredible relief. You just see your life can just be taken away from you.
As we head to the second trial, one of the possible outcomes here could be a conviction. That could be prison time. How much have you thought about that?
I think about it every day, about prison time, and it doesn't frighten me the way it did 3 years ago. I was arrested as a result of this prosecution. I've now accepted the fact that what's happening to me and the awareness this case has raised and the eyes it's opened, that is what my purpose is in Massachusetts and whatever effect this has in other parts of the country. And even if a jury got it wrong, or there's even more nefarious behavior on behalf of this prosecution, then just even more awareness will be raised. So I can accept whatever happens. Nothing will ever get the best of me or break me down.
There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed.
Right.
Is this a real concern that you have? Is this something that you are looking at, or have you just dismissed it as rumor?
I'll never just dismiss that as rumor. Something like that is, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence, that there was jury tampering? I don't have any specific evidence of it. Do I think that there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed, and who was dismissed very specifically? There were jurors who very, very clearly throughout, it's impossible to sit 8 feet away from 12 or 15 folks and not get an idea, just a chemistry idea of where those jurors are one way or the other based on certain, body language and facial expressions, et cetera, sighs and huffs and arm folds and leaning forward, leaning back, things of that nature based on certain witnesses. It's interesting that 3 of probably the most stalwart jurors who we believed, and I will go to my grave believing, were very supportive of the defense, ended up cast aside within minutes, not days or hours, within minutes of the jurors deliberating, within minutes of me standing up and giving my final summation. Those 3 jurors were gone. So is that a query? Absolutely. Have I dismissed it? I'll never dismiss it. Is there anything to do about it? Not so sure.
One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury?
Right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was a direct supervisor over the individuals that were testifying and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination, the presentation of our case. That person, that supervisor, we found out well into the trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest.
Is that standard in Massachusetts for just the DA's office to assign whoever they want to go be the sort of,
supervisor
of the jury? Yeah.
Yeah. Is it standard in Massachusetts? I hope not. I've never seen that in my life. But if I had a nickel for every time I said I've never seen this in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels. I've never seen that happen. It should never have happened. It's abhorrent to the system of justice in which we work. Those kinds of conflicts of interest they just can't stand. But they did, and we weren't even told about it. I mean, that was one of the most galling parts of that revelation, is that wait, this has been happening under our nose the entire trial. Ooh, and I'm just now finding out about it. We would have made hay about it as soon as we found out, and we did. But it was 10 minutes before I was about to stand up and close the case.
Some of the things that Michael Proctor said about you were objectively vicious. What was it like to be there in court and listen to all those texts?
another relief. So many moments in court were a relief to me because I've known these things in some cases for years and had to keep it amongst our inner circle. Nothing Michael Proctor texted and admitted out loud in court about me would ever offend me. I'm proud of my overcoming of health crises. Proctor was just letting the public know what I've known about Michael Proctor, who he really is. And it's just luck that, as I know it, Michael Proctor doesn't have a daughter. But those text messages, as vile as they are, I think are the least of his offenses.
Alan, you could have had Michael Proctor read one or two of the text. You spent hours having him read those out loud. I'm sure that was done by design.
It was. Everything that we did in that cross-examination of Michael Proctor was done by design. I wanted to make sure that I had an audience of 12 folks, an undefined 12 folks sitting in that jury box who were going to make a judgment about, not just about Kare Read, they were going to make a judgment about the prosecution and about the investigating officer in charge of the prosecution or in charge of the investigation. They needed to see and hear a full panoply of who this person really is and get down to the fabric of the human being. That's the only way they could assess the veracity of the entire investigation. As goes the investigating officer, goes the investigation. And the prosecution, the Commonwealth, wanted to hide that. They wanted to mask it. They didn't want to give those data over to us. They didn't want to give those texts to us. They tried mightily in front of the court to get those suppressed. Why? Because as goes the investigator, goes the prosecution. The texts were vile. They were disgusting. They were not just, as Michael Proctor tried to slough them off, regrettable. Regrettable, Mr. Proctor? Seriously? That's the best you can come up with in terms of what the things that you're saying and the bias that you're showing about a criminal defendant and accused who has yet to be convicted of anything? That's the best you can say is it's regrettable. It's far beyond regrettable. It's disgusting. It's disturbing. That man should not ever carry a badge. That man should not ever carry a gun. He should never have any authority over the community members ever again.
Are you surprised that he's been fighting for his job?
Yeah. What I think he should probably do is put his tail between his legs and get out of the jurisdiction and go find some other line of work, someplace where he can't hurt people.
How will Michael Proctor play in the retrial?
Oh, he's going to play large in the retrial. They can't. The prosecution, I think, probably wants very badly to take some magic eraser, some pixie dust, and erase Michael Proctor from the minds of the public, and certainly not from the minds of the new jury who's going to come in and assess this case. They're not going to be able to do it, not as long as we're breathing. Michael Proctor is going to be a part of this case, whether he likes it or not.
Because they don't necessarily have to call him, but obviously you have a right to call him as a witness.
Correct. And we will. If they don't call him, we will. We're not going to allow the Commonwealth to hide the truth from the last jury or this upcoming jury.
He's touched everything, everything.
There's no part of the case that he hasn't affected. No part of the case that he hasn't affected. He was in charge of the entire investigation. The personality and the character of the investigation is the personality and the character of Michael Proctor. They're one and the same. And we'll make sure that that's disclosed to the jury.
The feds devoted a lot of time and resources investigating what happened here. We are now years removed from that, and there's been no action taken. Why is that?
Well, I don't know that there's been no action taken. We don't know about any action taken. There's lots of, it's like
but no indictments.
No indictments, but it's like looking at a duck on water, Ted. The duck is very still, it's very stable, but underneath the little flippers are going crazy. I don't know what's happening just beneath the surface. I don't know what's happening. I'm not privy to what the federal investigation is actually, where it's going or how far it's led to this point. I do know that they were seminal in providing us with information. And when I say us, it's important to note, providing both sides. They didn't pick a side or choose a side in this. They provided everything that they decided was disclosable. They provided to both sides. The Commonwealth decided they didn't want to use it. As a matter of fact, tried mightily to keep us from using it. Thank goodness cooler heads prevailed, and we were able to utilize much of what their investigation or what their disclosure consisted of. But if it hadn't been for them, the Commonwealth had been hiding evidence from us for years. And it wasn't until the federal investigation and revelation came to pass that we actually sort of were able to look behind the curtain, which is where we should have been looking in the first place. So it was central to our presentation of our defense.
Leah Foley will be the third U.S. attorney, as far as we know, who will at least touch this case.
Right.
Do you expect that having a new head of the U.S. Attorney's Office in Boston will change anything?
I don't know. I have been incredibly impressed with the U.S. Attorney's Office in terms of the leadership under Ms. Foley's predecessors. Joshua Levy was central in making certain decisions about what to disclose to us, where the investigation was going. Again, I don't know what the full parameters of the investigation are, but I can say that I was very, very happy with what they did and what they disclosed, trying to get the truth out previously, and I hope Ms. Foley does the same thing. I'm looking forward to her continuing the investigation. I hope she does.
When you look at the scope of the federal investigation and all the things that were done, you received 3,000 pages from that investigation. Are there other things that might have been done or have been done that you think that should also be turned over or could be turned over?
I don't know. Again, Ted, we're sort of operating a little bit in the blind because I don't know what the full contours of the federal investigation consist of. So it's not like I can say, oh, well, they did this, but I don't have that information. I don't know what this is. The only thing that I have is the information that they provided to both sides. And then we culled through it to decide, oh, okay, is this relevant to our case? And nearly every page of it was highly, highly relevant material.
One of the things that the federal government did was hire this outside accident reconstruction team who would have no vested interest in the outcome of this case. Right. How important was those two accident reconstructionists coming in saying no way, no how?
I cannot describe the gravity of those two witnesses. First of all, they were unassailable in terms of their credibility and their credentials. There was nobody who testified that was more credentialed to talk about the issues that were attendant to them than those two gentlemen, those two doctors, PhDs. The fact that we didn't hire them, they can't be considered hired guns by the prosecution. The fact that the Commonwealth didn't even know their name. They were completely independent third parties who did not know Kare Read or this case, and they did not know that their assessment was attendant to Kare Read or this case. Central to their testimony, completely credible. I can't describe the gravity of those two witnesses and the impact that it had on the trial and getting to the truth. And what they said echoed everything that we had been learning during the course of our investigation on the defense side, which is that car was not damaged by hitting a human body. It did not hit a person. And John O'Keefe was not injured by being hit by a vehicle. No way, no how. It didn't happen. As one of the witnesses testified.
All right, ladies and gentlemen, that's what I wanted you to hear and see. There's also a point where Jackson says he's not getting paid for any of this. I find that also hard to believe as well. But that is the smoking gun, because we know, and this was just done on the Super Bowl just a couple of weeks ago, Super Bowl weekend, this was aired. We now know that there were emails between Jackson and his team and the people at Akara talking about how to do this. Oh, and not to forget the $23,000 bill that Akara charged the defense team to come and testify. When Judge Cannon appeared, let's say, visibly rattled after Mr. Brennan raised these potential discovery violations regarding Akara, their experts, Mr. Wolf and Mr. Rentscheller. Like I said, Mr. Allen's Pro Hoc Vice ticket, his license to practice are, could be in jeopardy. What if these witnesses are excluded from testifying? They may have to. Perjury. I mean, they got their opinions, but when they knowingly answer questions that, we've never met, have we? I've never asked you a single question before, have I? No. You're not being paid for this, huh? No. Lawyer up, gentlemen. Lawyer up. The prosecutor's not amused. The judge was not amused. She was apparently, obviously so upset after these emails were read into the record by Mr. Brennan today. And she took a break and she wanted to basically think about it because it could have grave consequences to the defense and to the attorneys for the defense. Now, of course, Mr. Jackson walked out of the courtroom this afternoon, and the reporter asked Karen, how was the hearing, those messages? Kare Read responded, I didn't like the state police to say something about the language we've heard. And then Mr. Jackson said, I had no idea what the judge was talking about. I have no idea. We played that video today of them in the court reading the transcripts. Oh, this is what it is. Oh, I can cut this part out of my testimony if you don't like that. Let me rework this. That is not somebody that is just a impartial person who just happened to do an investigation for the feds, but then was able to get retained basically by the defense. And like I said, got a $23,000 payday for doing it. Nothing wrong with that. If those guys can get $23,000 for their work and testifying, good on them. But the attorney should have had to disclose it. So, as we were saying, a couple of, I think, huge errors in the Kare Read case. Obviously, the mistrial snafu, as the defense never said, can we see if the jury's reached a verdict on any of the charges, or are we just going to declare mistrials to all charges? I'd say, but that's on the defense. That's on the defense. Should have had to have asked that. It is what it is. That's done. The Massachusetts Supreme Court, and I just saw that Kare Read filed her habeas petition in federal court. Basically, it is the exact same issue than what she says now. Whether the jury's unanimous conclusion following the trial that Ms. Read is not guilty on counts 1 and 3 constitute an acquittal and precludes re-prosecution, whether alternatively the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the juror's representation as to having acquitted Ms. Read, and 3, whether re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts for which the jury was not deadlocked, and assuming arguendo, the court found that counsel consented to a mistrial, whether the defendant's personal consent was required. That last one is, well, I know, Judge, I didn't do it, but you should ask my client, because after all, we now know, based upon this interview, she's intimately involved in all of these decisions. So yeah, that's not going to, hey, you know what? Habeas relief is the last resort. But I think this is going to get denied, kicked back rather quickly, because you have to be able to exhaust all of your administrative remedies before you can do this. She hasn't even been to trial yet. She may be acquitted. That's, I think, what the judge will say, that these habeas issues are not ripe as of yet because you haven't gone to trial. You haven't gone through the appellate process. You haven't gone through the post-conviction relief to do that. And so this is completely premature for this to take place for habeas relief. Hey, you never know, right? A lot of people don't do habeas work. It is a very specialized area of law. I have very, very limited experience in it, but I do know you have to exhaust all of your state remedies before you can go to the state. And one of those means you got to go to court. You got to exhaust all your appeals. You got to exhaust all your administrative remedies for post-conviction relief before you get to do that. All right. So there's Kare Read. We're going to have to wait. We'll do what we can to make sure we bring it to you. I'm going to do what I can to be here Wednesday when this comes out, because I think it's going to be a bloodbath. I think it's going to get ugly. I think that Mr. Jackson and his co-counsel, I think they got some explaining to do, and it's going to get ugly. And the judge may say, ooh, you may want to bring your own attorney. Mr. Jackson may want to bring his own attorney. I'll just leave it right there. You don't do this type of stuff. I know he wants to win. I love to win. I love winning more than I hate losing. Seriously, I love it. And I want to win. I want to win it, legally. I want to win ethically. And you can't cross those lines, and everybody, I remember as a young attorney, I probably pushed a couple of things that I would not do today because I was young and dumb. But this Alan Jackson guy has been practicing law for 30 years. He knows where the line is. You got to do everything above board. You got to do everything legal and ethical. You can push the limits. You can be aggressive, but you don't break the rules. And you certainly don't do it knowingly. And then you certainly don't make representations like that in front of the court, knowing that they are not true. Big, big problem. I think it's a big problem for Mr. Jackson. And, hey, we're going to have to wait and see. I don't have all the answers. I do have a, magic 8-ball. I don't have a crystal ball, although maybe we should just try the magic 8-ball, Frank, and see. Which one? Is it this one here?
Yeah, the police thing.
Well, I'm being informed here. They were paid for their services, a $23,000 bill for their services. That includes your testimony. Okay. That's how experts get paid. It is what it is. All right. Let's just ask the magic 8-ball here really quick. Usually we save this for our Patreon, but does Alan Jackson, the attorney for Kare Read, have some issues to deal with next week when he appears back in court? Magic 8-ball says without a doubt. If you can't trust a magic 8-ball, who can you trust, I guess? Anyway, we'll see. Let's see here. Let's go ahead and take a look at some of the questions here, see if we can't answer them. Let's see here. And what did you think about her? If she testifies, because, after all, she's got nothing to hide. Now, and don't get me wrong, I'm not criticizing her for not testifying in her trial. That is an absolute right protected by the Constitution. It's a very personal right, and you don't have a right. You don't have to testify. So I'm not holding her against that. So we'll just have to see how that ultimately turns out the second time around. Is she going to testify or not? But what we just watched with that video of her, that interview, I mean, she can't sit like that if she's in the jury chair. That's for sure. She just comes across as not very likable in that, and maybe that's just her. But if that's her mannerisms, somebody needs to, on her team, tell her, yeah, you come across like you got this kind of, I don't know, like you're bored almost look. I don't know whatever you want to call it look, but the reality of it is you come across as a little cold, and maybe that's the best way to do it. I just don't know. I just don't know. But I don't think she came across very good in that interview. And that was, basically pretty much scripted. So yeah. Yes, we are going to do our Patreon show tonight. Jason, feel free to join us. If you haven't become a Patreon member, now's the time to do that as well. Let's see here. Let's look. There's a lot of comments, but not a lot of questions. I heard it was expenses, not testimony. Well, the DA submitted the invoice in the court records. $23,000 of expenses. That seems like seems like a lot of expenses to me. And they're experts, ladies and gentlemen. They're experts. And I have no problem. We have paid experts lots of money over the years. Some of them do them at reasonable rates. Some of them are a little more expensive. But you got to have an expert that, is, I mean, their reputation, their credentials have to be impeccable. And you can't do anything like that. And who knows how this is going to turn out. But these experts from the Kare, they could have just ruined their careers over a case where, they get sanctioned by a court. They're going to have to put that on every, trial that they've testified to, on the list on their curriculum vitae. Is it worth it? Like I said, never met a client worth going to jail for, and I've never been paid enough money to jeopardize my law license. And I'm not saying that Mr. Jackson should lose his law license. This is his career. This is his livelihood. I hope he doesn't. I hope he hasn't done anything unethical. I'm just telling you, it doesn't look good. The judge was visibly shaken, visibly upset, and she was trying to control her emotions on the stand, saying, we're going to do this. And she was like, and we're going to do it next Tuesday at 10 o'clock unless somebody absolutely can't be here. And then Mr. Jackson's like, ooh, that day's not good for me. And I think you could hear Kare Read next to her talking, saying, no, that doesn't work. That doesn't work. Yeah, it's going to be interesting, ladies and gentlemen. Macy wants to know, I was wondering if AJ might be dismissed. Being referring to Al Jackson, but I think Kare will be able to testify no matter what. But if AJ misled the jury in the original trial, I don't know how he can stay. Like I said, he's not licensed to practice law in Massachusetts. He's their pro hoc vice, which is a form that you form. It's a motion that you have an attorney file, and you submit your records from your state where you want to practice, saying that you're in good standing, and you're admitted what they call pro hoc vice, VICE. PROHACVICE. And you get permission from the court, and you got to have kind of the local counsel do your guy. I'm admitted pro hoc vice currently in the great state of North Carolina for a case that we're handling. I've done it in other jurisdictions as well. I've done it in South Dakota, Wyoming, Oklahoma, South Carolina, and New Mexico. But when you go to other jurisdictions, it's kind of like when you go and visit a foreign country, you follow the rules, right? You don't want to do anything to get you kicked out, and you want to follow the rules and make sure you rely upon your local counsel for those little nuances under the law. Like, ooh, do we have to turn this over? Do we have to disclose that they were paid $23,000? I think it should have been disclosed. I really think it should have, but to be determined. But I think the defense in the Kare Read case next week is going to, I think it's going to feel some pain next week. I think it's going to feel some pain. This Mr. Brennan, former prosecutor, U.S. attorney, defense counsel, he's prosecuting this case. I told you guys. I don't want to say like I'm telling you, but I'm telling you, this guy's experienced. They brought in a, by God, no shit gunfighter to prosecute this case. The prosecution hired a gun to come in and prosecute this case because maybe they felt like they were a little outgunned during the first trial. I would say, yes, they were. And I think if they had Mr. Brennan on this case first time through, I think there would not have been a hung jury. It may have been an acquittal. I mean, it may have been a guilty verdict, not an acquittal on anything. So we will have to wait and see. All right. We're going to go do our Patreon show. So if you'd like to continue the conversation, hit the link down below, become a Patreon member, and you'll also have the opportunity to call in as well. The email exchange was for the defense. Yeah. The defense, the email exchange was from the defense to the Kare people. Now, the defense apparently turned these over recently to the prosecution. So, Gooseman, think we got that clear. But the fact is, the feds were turning over this stuff as well, and it was going to be discovered. And the defense looks like they tried to beat them, maybe a little game of mitigation as well. It's going to get interesting. The judge didn't seem to care. The point is, in the first trial, the defense got up there and made it sound like, oh, you're just here to tell the truth, Kare. You've got no dog in this fight, Kare. When in fact, they were basically paid defense expert witnesses. And that's how they should have been described to the jury. All right. That's all we have for you tonight. Thanks for watching. We'll see you next time. Come join us on the Patreon show. And remember, the Constitution matters.